Right, I welcome members to the 26th meeting in 2013 of the Delegated Powers and Law Reform Committee. As always, ask members to make sure they've turned off their mobile phones, please. Agenda item 1 is a decision on taking business in private. It's proposed that we take items 7, 8 and 9 in private. Items 7 and 8 are on the committee's consideration of its draft reports on the delegated powers contained in the Criminal Justice Scotland Bill and the Bankruptcy and Debt Advice Scotland Bill, respectively. Item 9 is consideration of the committee's first quarterly report for the parliamentary year 2013-14. Does the committee agree to take those items in private, please? Agree. Thank you. Agenda item 2 is draft instruments laid for consideration. The Single-Use Carrier Bag Charge Scotland Regulations 2014 draft, Scottish Government 2013-199. Members have before them a written submission from Mr Bill MacDonald, which the committee has received in relation to this instrument. Do members have any comments on the submission or the instrument, please? John.
Is this the appropriate time to comment? I note that we have received a letter from Mr MacDonald raising his concerns about VAT and corporation tax with regard to charging and the incorporation of VAT in the charge, and also the expense of corporation tax and the ramifications thereof. And I just would like that to be considered by the Scottish Government in addition to the points raised by our legal advisers. Just to set the record straight, absolutely, I'm in no position to judge whether Mr MacDonald's views are important or not, but nonetheless, if there is an issue, it would be better to be sorted out at the beginning of this process rather than at the end, and I think that we should take that opportunity to at least seek the views of the Scottish Government on Mr MacDonald's letter.
Thank you very much. On that issue, Steve.
Essentially, for this committee, Mr MacDonald is raising the issue as to whether what is proposed is intra-vires or extra-vires. I note that our legal advisers are not suggesting that this is extra-vires, that it is intra-vires. The sole reference to VAT is at Section 8 of the order, which permits any VAT on a charge that a retailer is making to its customer to be a cost that may be deducted from the net proceeds of charge that retailers are making. It is very clear that this charge is not a tax because there are no receipts of financial benefit to the government in any way. This does not affect the VAT regime. It most certainly does not affect the corporation tax regime. So therefore, given that this committee has previously taken the view that it should take a view on matters of vires in relation to instruments that are before us, I believe that today we should take the view that this is intra-vires, and therefore we should not refer this to anyone else, be it the government or elsewhere.
Very much. I'm wondering if I could, forgive me, John, I'm just wondering whether I could pick up on the issues that our advisers have brought before us and then see where that leaves us in totality. Would that be agreeable? Thank you. Because there are some points that have been raised by our legal advisers. Firstly, bags used for the supply of medicinal products or listed appliances in accordance with the prescription and bags used for the supply of pharmacy medicines are exempt from the charge imposed by the regulations. Circumstances in which a product is supplied under prescription and other relevant terms are defined in the schedule to the instrument by reference to statutory provisions which have been repealed or amended. These references are therefore not accurate and do not achieve the intended legal effect. Does the committee therefore agree to draw the instrument to the attention of the Parliament under Reporting Ground I, as the drafting is defective in this respect? Oh, we agreed. Please, thank you. Does the committee agree to note that the Scottish Government has undertaken to review the accuracy of all definitions in the instrument before laying a final draft for approval by the Parliament? Thank you. Second point raised by our legal advisers relates to a drafting error. In Regulation 13.5, the reference to paragraph 4A should be a reference to paragraph 4C. Does the committee therefore agree to draw the instrument to the attention of the Parliament under reporting ground, under the general reporting ground, as the instrument contains a drafting error?
Agreed.
We do, thank you. does the committee also agree to note that the Scottish Government has undertaken to correct this error in the final draft laid for approval by the Parliament? Finally, in this regard, does the committee also agree to welcome that the Scottish Government's commitment to review what the meaning of domestic premises is and whether it's sufficiently clear in Regulation 13.5 in light of the consultation responses it receives? Thank you very much. Right, having dealt with those, can we just return to the issue of what we should do with the comments which we have received? Can I think, actually endorse what Stuart Stevenson has actually just said, on the basis that all the other issues would appear to be those for the policy committee rather than ourselves, if we are content that it is within varies, which I think actually our advisers are telling us.
Note that our advisers have taken the trouble to put this letter in front of us for our consideration. I'm certainly not competent to judge whether it's in varies or not. I think it would not be unreasonable for the Scottish Government to just give us their views on his letter, given that our advisers have thought his letter sufficiently important to put in front of us as a committee. And I don't think that that is an unreasonable request, given the stage we're at in this process, and that we will be seeking views and responses from the Scottish Government on the matters you, Convener, have just raised.
Yeah. Let me say I don't think it's at all an unreasonable request. Do members have any other comments, please? Stuart?
I understand informally, Convener, that the correspondent to the committee, and it's perfectly proper that correspondence of this nature be put in front of the committee, and I think it's done in a way that is entirely neutral as to its content. I note, however, that the correspondent has not sent this to the government, and I would suggest if we were to take any action whatsoever, if this is a matter for the government, then it is a matter for the correspondent to raise with the government. Our sole interest in the matter is a matter of virus. It is clear that the legislation, when you examine Section 8 of the order, does not affect the operation of the VAT system or impact VAT legislation, nor does it in any way do similarly in terms of corporation tax. We are not getting any contrary advice to say it's extra virus, therefore we should follow the process that we have in the past done, in that in matters of virus, if we consider it's intra-virus, we take no further action. The official report of this meeting will be sufficient indication of what we've, of our consideration of the matter, and it should be closed.
Okay, I'm in the committee's hands. Are there any other thoughts or comments? I certainly don't want to be divided on this. I don't think it's going to help. Richard?
A lot of sympathy with what Stuart says in terms of whether this is intra-virus or not. I tend to agree with that point. But I also have a lot of sympathy with what John said. In terms of belt and braces approach, Convener, I think there's little to be lost in simply drawing the Scottish Government's attention to the fact they've received this letter and simply asking them to state their view. I imagine, Stuart, they will make a very robust case. The point that you've made, I don't see as any real harm or anything to be lost in the committee taking a belt and braces approach and just flagging up to the Scottish Government that it would be interested in the response to the points which have been raised.
Go on.
Convener, I suppose my difficulty is that this correspondent, I understand, has deliberately chosen not to send it to the government. It is not our job to be his postman.
With respect, it is a free country still, and our correspondent can send to whomsoever he wishes a correspondence.
Can I suggest a way forward? Because, sorry, the last thing we're going to do is to be divided by this. I would suggest that would be counterproductive. Can I suggest that we might note, I think we should write to the government, note that we have received this, passing it on to them with our best wishes. Perhaps that's not perhaps quite what to say, but you're with me. Note, and we can also point out to the government and to whomsoever else might be interested that as far as we're concerned, we do believe this is all entirely intra-virus and it causes us no concerns whatever, but the government might like to see this correspondence for what it's worth.
Comments on it?
Indeed.
No, Convener. We decide, if I may, the matter of virus. And I think we should make that decision. We pass it to the government for information only.
With respect, we do not decide the matter of virus, and this committee has divided before on the matter of virus, and I suggest that the way we're headed, it will probably do so again.
I endorse the convener's approach.
Sorry, I think what I suggested was what actually Mr Stevenson is suggesting. I didn't.
No. I was
we're passing on
responding.
as a matter of information, but we are clear, I think, as a committee, that this is within Barry's and we have no concerns about it.
Yeah.
Are we comfortable with that?
It's up to John.
Forgive me, I'm not certain what you are saying.
What I'm saying is that I think the committee believes that we don't have a problem with what is on the submission, but we're happy to send it, and that we're going to send it to the government for information, so that they can respond to it should they feel it's appropriate to do so.
I would still seek comment on it in a belt and braces approach, and that I cannot see what harm that does. I cannot see why the government would not wish to say, perhaps in one line, that there is no problem here, but that is a belt and braces approach, which is what this committee is about, and avoiding problems at the earliest opportunity rather than building up problems
So
for
we
the future.
only have to ask whether it has any comments that might be relevant to us.
Yes.
Indeed.
Given that this correspondent is refusing to send it to the government, I think if this correspondent believes this is a matter for government, it should correspond with government. We, as a courtesy, should make government aware of the correspondence, but it is not up to. I just don't accept. And you know, at the end of the day, the committee will decide what it decides. I don't accept. It's for us on this matter to ask the government for a response.
I'm not suggesting that we do ask for a response. I'm suggesting that we invite them to comment should they wish to do so.
If that is the formulation, convener, then I would be content.
Okay.
And to comment,
I mean,
should
it's
they
taken
wish
us
to
a long
do
way
so.
to get
Right,
there,
I will
but
accept
I
that.
said that. Yep.
Okay, I think.
Yes.
Sorry, Christian, sorry.
And making sure as well we copy the leading committee.
Indeed.
That's the most important, because at the end of the day it will be for them to do it.
Okay, sorry, it's taken us a long way to get there, but I think if members are comfortable with that, then that's the line we will take. Thank you. Which I think brings us a long way around to agenda item 3, instruments subject to affirmative procedure. No points have been raised by our legal advisers on the Budget Scotland Act 2013 Amendment Order 2013 draft. Is the committee content with that, please?
Content.
Thank you. Agenda item 4 is instruments subject to negative procedure. No points have been raised by our legal advisers on Beekeeping, Colonsay and Oronsay Order 2013 SSI 2013-279. Nor on the Sligachen, Isle of Skye scallops, a several fishery order 2013 SSI 2013-280, nor on the public contracts Scotland and Amendment Regulations 2013 SSI 2013-282, nor on the title conditions Scotland Act 2003 Conservation Bodies Amendment Order 2013 SSI 2013-289, nor on the Act of Sederent Commissary Business 2013 SSI 2013-291. Is the committee content with these instruments, please?
Content.
If not, perhaps with my pronunciation. Agenda item 5, instruments not subject to any parliamentary procedure. The Post-16 Education Scotland Act 2013, Commencement Number 1 Order 2013, SSI 2013-281. The instrument commences provisions within paragraphs 27 and 8.5 and 22 to the schedule of the Post-16 Education Scotland Act 2013, which amend and repeal provisions in the Higher and Further Education Scotland Act 1992 and Further and Higher Education Scotland Act 2005, respectively. However, the instrument fails to commence paragraphs 2.1 and 8.1, which provide for the amendment of the aforementioned 1992 and 2005 Acts by subsequent subparagraphs. While such drafting is not considered defective, the commencement of paragraphs 2.1 and 8.1 would have been appropriate in order to exclude any doubt as to whether the commencement of the specific provisions within paragraphs 2 and 8 could be properly interpreted as referring to the aforementioned 1992 and 2005 Acts. Does the committee therefore agree to draw the instrument to the attention of the Parliament under general reporting ground as it fails to commence certain provisions of the Post-16 Education Scotland Act 2013?
Agreed.
Thank you. Agenda item 6 is the Tribunals Scotland Bill. This item of business is the consideration of the Scottish Government's response to the committee's Stage 1 report on the Tribunals Scotland Bill. Members have seen the briefing paper and the response from the Scottish Government. Members may wish to note that unless substantial amendments are made to the delegated powers at stage 2, it is unlikely that the committee will consider the bill again. Do members have any comments, please? Richard.
Yeah, I know the issue of whether it's appropriate for the rules regarding locations of tribunals to be set in tribunal rules rather than to be subject to discussion in Parliament. So I think it's worth us flagging this up to the lead committee and again asking the Scottish Government for their comments on that particular point.
Members may wish to write to the Scottish Government to seek further clarification as to why the power at section 56(2) on the venue for hearings is subject to tribunal rules rather than to some other form of delegated power. Yes, we agreed.
Great.
Thank you very much indeed. That finishes agenda item 6, and I now move the meeting into private.